Okay, welcome to Court Procedure and Evidence. This is a class being offered here at Wake Tech. The general course number will be CJC, Criminal Justice, 132. Some of you will be listening from different sections, either our hybrid sections where we've met once a week, or our fully seated sections where we've met twice a week, or some of you are just online, so this is the only chance you're going to get to hear my dulcimer tones lecture for you. We're going to construct this course by using the text, obviously, and this text will be outlined in a number of chapters, and we will cover each one of these chapters in turn. Basically, each chapter should take us approximately an hour to an hour and a half to cover. We'll be using the latest edition of the text, but there will be quite a bit of supplemental material that I'll be adding in. And when I mean the latest edition of the text, this is Criminal Procedure 10th edition by Joel Shamina. This is Cengage Publishing. I'll talk a little bit sometimes about assignments in here, but be aware that depending upon what type of section you're in, whether you're in the fully seated, the hybrid, or the online, you will have different types of assignments or sometimes no assignments at all. Having said that, let's go ahead and jump in. This is going to be chapter 1. This is kind of an introductory chapter. It's a little bit unusual in that we won't be covering a specific topic per se, but the general idea. Okay. So this is, first of all, when we talk about this chapter, it's going to be the outline of the chapter itself, but there's also going to be additional material on reading cases. There's also going to be a little bit additional North Carolina material on it. This class is really structured for a North Carolina practitioner at a level where you're going to be in contact with evidence in the legal sense. Okay, so one of the things it starts off with, and this is pretty common now in text, and I'm going to add a couple as well, is recent events that will touch on the field of court procedure and evidence. So it starts, which is now surprisingly 6 or so years ago, with the Ferguson, Missouri police shooting. And if you recall that one, a young black man was walking in the street. He was confronted by a white police officer. There was a fatal shooting. This sparked a series of riots in Ferguson and civil disturbance. And then, of course, there was a grand jury. We'll talk about grand juries and evidence in grand juries a little bit later, but this triggered some evidence and procedure that we can look at. The risk of death or serious injury from terrorist attack. There's different reports. And what we're going to focus on primarily in this one, which is going to be the Apple iPhone locking controversy and its evidence and procedure there. But also, I think, to be a little bit more current than your book is, we could talk about the evidence and procedure regarding the Washington, D.C. insurrection. I know it goes by different names, which occurred on January 6th, 2021. Now, all of these events, if they're going to become crimes, first of all, you have to ask the question, did a crime occur? And obviously some people will debate whether a crime occurred both in Ferguson, whether there was really a crime in Washington, D.C. If you want to find a crime, how does that happen? I mean, there has to be some evidence of it. And then second of all, what evidence exists to prove someone, if we decide that indeed there is a crime, are guilty of the crime or are innocent of the crime? So what evidence is there? How do we get that evidence into court? How do we examine that evidence? What do we look at it? That's all what we're going to be doing in here broadly. So the next idea is criminal procedure ideals in the real world. We have to remember that there's really the theoretical that we're going to be looking at, the theoretical idea of what is evidence, what's admissible, what isn't admissible, when is admissible. And we have to counterbalance that with operating in a real world environment. So one of the things you have to decide is how much freedom are we going to grant people And when that freedom begins to restrict the availability of evidence, is that a good or a bad thing? And so, in other words, it will sometimes limit what we'll do. Too much freedom could lead to chaos and a loss of security. You're not free. Too much security can lead to a loss of freedom. I mean, you're perfectly safe if you're locked up in solitary confinement, but it's not a very great life. You're perfectly free if you're, on a desert island or you're in a complete anarchist situation, but it's not a very pleasant situation either. So what we're seeking is, since we're living in the real world, is proportionality. Using the state power just to the extent that society is willing to accept the restrictions that power places so that it can accomplish its job, but that we can remain free. So how much power do you need to prevent crime, investigate crime, prosecute, have sentences, review what went on, and taking into account this idea of freedom and crime control, public safety and individual autonomy. So we also have to realize that no system exists in a vacuum. So if we go back to both the Ferguson 2014 and we go to the Washington January 6th insurrection, we have to ask the question, is there equal justice here? Is there accuracy here? Because it's a real world. It's not just an idealized theoretical exercise. Should we seek equal justice? Equal justice is the impartial treatment of the innocent and guilty by the law, by the prosecutors, by the police, by the defense, by judges. Now this can really conflict with practical reality. And this impartiality often depends upon, and that should be our preconceptions or our conceptions of justice. One of the things we do want to be careful is that whatever we do, we are adhering as close as possible to the truth, that we are accurate. We don't want to have innocent people caught up in a system and be injured. We don't want guilty people to escape their punishment. So I think it's important that there's other balancing factors going on that really impact this. All right, so one of the things that we have to realize is you can have a tremendous amount of empirical evidence, which is based on research and policy, and you can also have the difference between what we know empirically and what is legal evidence. So legal evidence has significance to a crime, but you might have research to show that something else is happening here. Let me give you a quick example. You can arrest an individual for a crime. Let's suppose you arrest an individual for possession of marijuana, one of the most common crimes which you're still arrested for in the United States. All right, so individually you could prove, did John Doe possess marijuana? And you might say, okay, did I conduct a search? What did I find in the search? Did he make a confession? What did he say in the confession? Did I interview witnesses? What they said in the witnesses? That would all be legal evidence. But then suppose I told you that John Doe was a member of a community. Let's make a fictitious community. Let's suppose he's a Martian. If I could show you data that the only people arrested in North Carolina for simple possession of marijuana anymore were Martians, or that Martians were arrested at 10 times the rate of regular citizens. Well, yeah, you've got evidence for the individual that something's going on, but you also have some empirical evidence that there's something going on outside of the individual action. So sometimes the application of one can conflict with the other, and you might say, well, we're having unequal enforcement here. There might be some bias or prejudice going on. You can really see, even though I used the fictitious example of a Martian, how this could be played out in the real world. Suppose we have an unpopular minority at a given time in history, LGBT currently, I would argue, or African Americans in the 1960s or 70s, or even today. If you look at the arrest rates for North Carolina for simple possession, if you're an African American, you're arrested at about 3.5 times the rate of the general population. And then there can be things that are hidden from us, and there might be empirical data that shows that you're getting some different enforcement, but you might have to dig a little deeper. Quick example. Arrest rates for homicides based upon gender. It's about an 8 or a 9 to 1 ratio of people arrested for murder being male versus female. Well, in the abstract, if you didn't look at, say, practical evidence, okay, and you didn't look at greater empirical evidence, you might say, well, this is a bias based upon gender. You're not arresting men and women at the same rate. Well, here's the thing. You do a little bit more research and you find out that, yes, indeed, men commit more homicides than women do. That really means that, empirical evidence, basic research, policy research, has to be very thorough before it can be admitted. It has to deal with all sorts of things. All right, let's go ahead and move on. Mainly what we're going to be talking about in this chapter is a single case. And that case occurred in 2016, about 6 years ago now. And it's going to be our template or example for the balance between, do you want to be free or do you want to be safe? Do you want privacy or do you want security? Do you want liberty or do you want justice? So what happened here was this was all about an iPhone that was used in a terrorist attack. I don't mean it triggered the attack, but it had information or, to use the parlance we're going to use, evidence about the attack on it. So the FBI got the phone. An interesting thing about the phone, if you read it was a phone issued to the terrorist, who's now dead, by a county organization. I think it was a county in California, San something or other. So the phone was not his physical possession, but the phone was encrypted or locked. And the FBI had it but couldn't open it. It had a kind of unique security feature that if you tried the password 10 times incorrectly, it would wipe all the data on the phone. And that was for instances of people trying to hack into phones they stole. So the FBI goes to Apple and says, hey, give us technology, give us a way to break into this phone, to bypass the security feature. And essentially what they were asking was, develop this technology, because it didn't exist. Apple didn't have itself the capability. And Apple said, well, no, we won't do that. We won't create a vulnerability in the system. So we're off to the races. And this is going to be a struggle to get that evidence, but also balance those two factors. So how do we know about all this? Well, that means we've got to understand what we're talking about here, and we're going to have to read the case. And you're going to have cases in your text. One of the things I quickly like to tell my students is that you are not reading trial transcripts. It's not as if you're in the courtroom reading individual trial records. This is what Bob said, this is what Fred said, this is the admission, this is not. You are almost always, and this case is a little bit of an exception to that, but you're almost always reading appellate cases, not a transcript, but what you're hearing is arguments between two lawyers, or two groups of lawyers, two law firms. Sometimes one of those law firms is the government, arguing a matter of law, and for our purposes mainly a matter of evidence, admissibility. So what happens is there's usually a trial. As I said, it's not quite the same in this one. There's a motion that we're appealing, but there's usually a trial, and there's a decision from the trial, and someone appeals. That's why you're getting to an appellate, an appeals court. And one of the things that comes as a shock to many students is that you don't appeal based on the idea you're innocent. You don't say, hey, you guys made a mistake, I shouldn't be in jail. I mean, you're ultimately arguing that very often. But instead what you're really arguing is, hey, you guys made a legal mistake. You misapplied what the Constitution is, or what the criminal statutes or evidentiary statutes or procedural statutes, whatever the critical statute is, should be applied in this case. So you're reading a little bit more of a technical legal matter than practical reality. Okay. Now, let's look at how we cite things. And again, this is a bit of a digression from your text, but I think it's helpful. So if we look at the first case here, very famous case, this is Brown versus the Board of Education, 347 U.S. 483 in brackets 1951. If you see the abbreviation U period S period, and that's it between two numbers, you know that that is a United States Supreme Court case. So to read this case, it means Brown versus Board of Education is the shorthand name of the case. Sometimes you'll just hear it called Brown. It's a very famous case. It's the desegregation case. Brown versus Kansas City Board of Education, or the desegregation of public schools. The first number there, 347, is the volume you're going to find this in. The second number you're going to find there after the court is mentioned is the page it begins on, or if you're citing a particular part of that, you'll see two numbers there, like 483, comma, 117 or 493. That means the page I'm citing off of. And then finally, the year the case was decided, not the year the case was filed. So if you had someone sued or someone arrested today in 2022, late 2022, it's entirely possible this case wouldn't go up on appeals or be decided till 2023 or 2024. All right, so the second citation there, which is kind of made up, Smith versus Jones, 258, Fed 3rd, 265, 4th Circuit, 2001. This is the next level of a federal case. This is the case name again, Smith v. Jones, which is versus, okay. It's then in a volume, 358, and then it's the reporters, federal reports. It's the name of the publishing book. Used to be publishing book, it's almost all online now. And then the page, what circuit it was in. So the federal appellate courts are divided into different circuits, so you'll see whether it's the 4th Circuit, the 5th Circuit, the 9th Circuit, and on and on and on. Now, if you do happen to get your hands upon a case, you might see a federal district court case, which would be a little bit different, and it's still structured pretty much the same. You see this case of Lasonde versus Pleasant, 167, which is going to be your volume again. Federal Supplement second, it's your Federal Reporter abbreviation, and what it means is that's the book you're going to find it in. Northern page 1108, and then it's the Northern District of California is where you're going to, and it's decided in 2001. All right, so that's how the federal legal citations look. Let's take a look at how the state legal citations look, and I picked North Carolina here. So you'll notice that it is similar, but sometimes they add some extra numbers. So let's look at a North Carolina Supreme Court case. Crowell versus State, 238, NC 583, comma, 402 Southeast SE, 2nd, 207, 1991. It's a North Carolina Supreme Court case. So why do we have those extra numbers? And I didn't flesh it out completely underneath because a lot of it's repetitive. First of all, you got the two parties, Crowell versus State, volume, NC. If you see the abbreviation of a state, it means, and it's just that state, there's nothing after it, means it's that state's Supreme Court or its highest court, because not every state, confusingly enough, calls its Supreme Court the Supreme Court. Page 563. Now the second numbers is, and here's the thing, is there's a formal publication, essentially by a quasi-governmental agency, which are called the reports. But there is a secondary publication, which is quasi-private, the exact same case, but sometimes you don't have access to one or the other. They're both published essentially at the same time, and it's the same case in two different books. So that's why you're seeing two different numbers. 238 North Carolina 563 means the North Carolina Supreme Court reports, published by the government essentially. 402 Southeast 2nd, 207 means it's published by this private entity. West Publishing is actually the name of it. And because it's the Southeast second, it's going to have a lot of, unsurprisingly, states in the Southeast. So like North Carolina and South Carolina being in Georgia. All right, so let's look at the next appellate court that we would see, and that's in North Carolina. This case would be Melvin versus St. Louis, volume number 132, North Carolina APP 43. That means North Carolina Court of Appeals. We have two appellate courts in North Carolina. We have, just like the feds have two. We have our Supreme Court, North Carolina Supreme Court, and our North Carolina Court of Appeals. The federal appellate court is often called the circuit court. Our appellate court is just called the appellate court. Then there's another publication, private publication. Okay. Finally, even though I didn't give you an example, you should be aware that we have two basic trial courts. We have the Superior Court, which in most cases, but not all, handles our felonies. And we have our district courts, which handle our misdemeanors. And it doesn't mean, oh, then all the murder cases are in Superior Court and all the, unimportant ones are down in district. That's not true. We just had a tragic accident in Raleigh, as I am recording this, where there was a Christmas parade, and one of the men driving one of the Christmas floats had modified his truck, and it created some sort of problem. It's not exactly clear what. And he lost control of the truck, and he ran over a young girl, and killed her. That's a homicide, but North Carolina has a statute called misdemeanor death by motor vehicle, where you kill someone and it's not because you're, egregiously or terribly drunk or reckless. We have a felony death by motor vehicle. This is a misdemeanor death by motor vehicle. So he's going to be charged with a misdemeanor death by motor vehicle. I saw the charges. So he'll be tried in district court. So there'll be a murder trial in district court. So when we say felonies in North Carolina, what that means is you are facing a long prison sentence. Usually the felony misdemeanor split in North Carolina is that the felony misdemeanor split is 2 years or more, although practically it's 1 year or more, that you'll serve in prison. And 2 years or less, you're going to serve in a jail. That makes it a misdemeanor, although practically it's almost never more than a year. Okay, let's move on and keep talking about the Apple case. Let's go back to our text a little bit. All right, so what are the facts? And one of the things that happens in an appellate case, if you read it, is the very first part of many appellate cases is an outlining of the facts as they're understood by the judge. He has read or has been given access to or is part of the brief that he got about the facts. So Saeed Rizan Farouk was one of the shooters in this San Bernardino attack that killed 14 people and seriously injured 22. He was killed in the subsequent gun battle. Farouk's iPhone 5C was recovered. As I said, it was issued to him by a county in California. I'm going to assume San Bernardino County, but that might just be the city. But it had a 4-digit passcode, and that 4-digit passcode, if you entered it incorrectly 10 times, would wipe out the underlying data, as I said before. So it was really important that the FBI, and the FBI had the phone, for them to be able to put it in correctly. So FBI asked Apple to create a new version of its operating system, iOS. We'll just call it iOS, not iOS. That was my mistake. That you could put into the phones that would let them get to random access of the memory and disable security features. They're not just saying, hey, do you know how to hack this? They're saying, create a way to make us hack this. It's like saying, if you had a safe in your house, I don't just want you to give me the combination of the safe, because you say, well, I don't know the combination of the safe. I want you to go out and hire someone that can break into the safe. So Apple declined. They said, no, we're not going to do that. And here's really where the case began. And I'm going to show you the court order. So this is an actual cut and paste of the court order. You'll notice that it's the U.S. District Attorney there, Eileen Decker. And then it's got everybody else that's involved in the case. You've got another assistant U.S. attorney. You've got the chief of the National Security Division. You've got a third assistant U.S. attorney. You've got the chief of cyber and intellectual property crime section. You've got the terrorist and export crime section. All of these sue Apple. Okay, so all of them named there, okay, are going after Apple. And this is and you can see down here, in the matter of the search of the Apple iPhone seized during the execution of a search warrant on a black Lexus IS 300 California license plate. Okay, so the FBI comes in and it files. If they file this in federal court, so this is all going to be handled federally. And in federal court at this level, because we're really not at the trial court level, we're just handling requests for information, requests for evidence. You can file that in front of a federal magistrate. So they ask U.S. Magistrate Judge Sherry Pyam to compel Apple to turn over the information. And what they did was they subpoenaed it. It's not a classic subpoena, hey, give us this information. It's a request for an order under All Writs Act of 1789. Now this should raise some obvious questions for us, and the obvious question is, what the heck is this? Well, first of all, the order said that Apple should have to write new software that would bypass or disable this auto erase function, so that you could make more than 10 attempts, because you could do it with just a brutal attack. You could go in and theoretically, it's a 10-digit code, so if you can do it, if you can submit the password electronically, there's 9,000. Well, I guess there's actually 10,000 because you can put in 4 zeros or more, 4 zeros. So there's roughly 10,000 attempts. Well, a computer can make 10,000 attempts to enter digits in a matter of seconds. So FBI wanted them to, first of all, not just have to use the physical entering of the digits, which could take a long time if a physical person was putting in 10,000 four-digit numbers, but to do it with a computer. And that the FBI's passcodes would not be delayed but prioritized, it's kind of in spook, and that Apple itself would produce this software to break into it. Now this is a pretty big ask. You're not just asking for how do we get in, we're asking for make me a way that I can get in. So it's a big ask. And how can they ask this? Well, they can ask this by the All Writs Act, which is not a common piece of legislation or statute that's been relied upon, but it does exist. What happened was in 1789, shortly after the foundation of the American Republic, this is more than 230 years ago, Congress passed a law that said in part, the court may issue all writs, writs that are necessary or proper or appropriate in aid of their respective jurisdictions and agreeable to the usages and principles of law. An alternative writ may be issued by a judge. That means this is an order to carry out my order. That all writs lets me essentially give an order that will be obeyed. One of the last times it was used in electronics was in 1977. And what this did was it required the agencies that were using phones to set up what is called a PIN device that records all the phone numbers called from, there's another error there, I'll fix that in post, from a specific phone line. And in 1997 require all cell phones to geolocate their cell phone, all cell phone providers. So this had been used a little bit before, but this was an extension. And one of the things I say very often is if people have tools, they'll use them. And as whatever tool gets developed, they will not only you know, use it a little bit, they'll try to extend it. They'll try to make it more and more and more useful to them. Okay, so Apple refused the order, and they appealed. Judge Pime had given Apple 5 days to go ahead and do this, to appeal if they said the writ was unreasonably burdensome. So this is where the CEO, the Chief Executive Officer of Apple, Tim Cook, got involved. He said this is unprecedented and it would undermine the security of all the customers. Essentially what the government is doing is asking us to make our phones less secure. And if you want us to create an operating system that is easy to break, people won't use our phones as much. It's not as valuable. Apple was pretty upset about this, and it really set off this conflict very much between the two major factions. The factions that wanted freedom and the factions that wanted security. What we're going to talk about quite a bit in here. So here's your timeline. In March 21st, 2016, the FBI, which we were supposed to have a hearing on the 22nd, said, why don't you hold off for a minute? We may have a way to get in otherwise. And then a week later, on the 28th, they said, we don't need it. We've found a way to hack in. Now, there's still debate as to exactly what the FBI did here, because a lot of it's secret. They don't want the general public to know how they can get in their phones. One of the most common assumptions is they went to a third-party white knight hacker. A white knight hacker is someone that will break into secured systems for law enforcement. And I believe this was an Israeli company or group, if I'm not mistaken, broke in for the FBI. Very often the federal agencies have to pay for this, or the state agencies. So again, this kind of highlights why we have here is a balancing act. You're going to balance community security and public safety on one side and the individual privacy on the other. How much do you want people to, or the government, to be able to know everything about you? And this is, something we've struggled with for 230 years. It's a quote taken a little bit out of context, but Benjamin Franklin once said, "Those who will give up a little freedom to get a little security will get neither the freedom nor the security, and will deserve neither." I'm paraphrasing that quote. He's much more elegant than I. But there's always got to be this balancing act. Now, if you're really interested in this case, here is an interactive link to some of the details on it. Now, this is a 1-hour video. You do not have to watch this. This is I think it's on YouTube if you go to that link. It may not be, but it's a 1-hour video just focusing on the case. It gives you a lot more of the nuance, a lot more of the detail. Obviously, in the time I've had here, I've really simplified a lot of this. Okay, one of the things I want to do now is move on to some information that's not quite in your text, but I think is helpful groundwork to lay for things that we're going to be covering later. And one of the first things is, where are all these rules you're talking about, Mr. Chapman? Where are they coming from? Well, this is the North Carolina Rules of Evidence with Objection, 5th edition. This is the most current edition. Every attorney that is going to practice in North Carolina court has a copy of the Rules of Evidence. Now, the North Carolina Rules of Evidence are patterned after a uniform standard set of evidence that was created by the Supreme Court. In the bad old days, you might say, debatable point, each state could create its own different rules, and to some extent you still can. Okay? And you can, even once and almost every state has adopted very, very similar rules of evidence, but there can be variations. Let me give you an example. Some states will recognize that a wife or husband does not have to testify against their spouse. Some states will recognize that a psychologist has the same privileges not to testify against his patient as an MD, a medical doctor. Other states will come to different conclusions. So there can be some variation. But pretty much, to simplify this story, back in the middle part of the 20th century, the Supreme Court said, hey, it would really be great if we create a standardized body of evidentiary rules and then get each one of the states to adopt them. Most states did this. And you can see how it really would simplify the job of the federal court system and attorneys. Because in most cases, what is evidence in California is evidence in Carolina. What is true in North Dakota is true in Wisconsin. So it really helps. Most states have adopted this. That's the North Carolina Rules of Evidence. We're up to the 5th edition, which hasn't changed that much. So what's in the actual structure of it? I'm glad you asked. There are basically 11 sections. These are the titles of these sections. We'll just go through them quickly. Section 1 is your general provisions. Section 2 is judicial notice, which is when you have to assume certain evidence is true. Presumptions, which is very close to judicial notice, but different enough that we'll talk about it. Relevancy, doesn't matter. Privileges, you don't have to testify because. Witnesses, what did you see, how are you going to do it. Opinions, what tests and stuff did you run, and experts. Hearsay, what did you hear. Authentication, identification, is that the real thing? Contents of writings, recordings, and photographs, which obviously with the rise of the cell phone and the rest has become much, much more important. And then miscellaneous rules. Now under each one of these is a series of rules. So you might have, and I'm going to make up something, under hearsay you might have, usually the lower the number is a definition, you might have 801 identifies what hearsay is. 802, which is the general rule about hearsay. 817, or 817, excuse me. 817 might be some unique thing that North Carolina adopted about hearsay. So under each one of these will be individual rules, and all those rules will start off as in section 1, it's 100s. Section 2 is 200s. And it'll be from, say we're in section 6, 600 being the start, to 610, 620, 630, 640, 645, 653. You can see it goes up and up and up. So there's theoretically 100 possible rules in each one of these sections. None of them have that many. Otherwise that book would be incredibly thick. Of course, even after you have a rule, whatever rule we're talking about here, you've got to interpret that rule. So I can say this is the definition of relevancy, this is the definition of competency, this is the definition of materiality, which are the three really important components of evidentiary rules. But then you have to have cases that flesh out what relevancy means. You might say, this is a writing, okay? Well, what is a writing? Is a writing also a tweet if it's electronically? Is an email a writing? Does it have the same protections as a letter I put in the mail? Does it have the same protections as a tweet? Are there different levels of protection? What if I sent it on a governmental computer from work, but it was a private communication to my wife? So you can have a rule. It can talk about the disclosure of information and whether they do or they don't need warrants, for example, to access it, but that doesn't end the question. You're going to need case law to interpret it. So even though these are the rules, they're just kind of the beginning. Look at it this way. There are rules for football, right? But every team that plays football has a book of plays, how they use the rules to win the game. All right, so in that in the rules, it might say you have the right to throw a ball forward, the forward pass in football. But each team will have, okay, we've got the forward pass, but this is how we're going to do it. This is a down and out. This is a stick and go. This is whatever the specific application here can be different. So even though I've given you the broad, the constitutional, and a little bit narrower, the specific rules, be aware that it gets very technical very quickly. Far more technical than you're going to see in things like TV. All right. What about procedure? The last point here. Because if you have rules, you also have procedure. And this class is evidence and procedure. So what do we mean by procedure? All right, you get arrested for a crime, right? When do you get to see the magistrate? That's not an evidentiary rule, that's a procedural rule. You want to file for a search warrant because you're a police officer. Where do you do it? What can be in the search warrant? So currently in North Carolina, if you want to find it, you're going to find these in Chapter 15A of the North Carolina General Statutes. NCGS, as it's called, North Carolina General Statute, are all the rules that have been passed by the state legislature, the North Carolina State House, the North Carolina State Senate, signed by the governor and enshrined as laws. Now, some of them are about things that have nothing to do with the court system, right? Some of them have to do with election proceedings. That's got nothing to do with the court system, right? And some of them, are the actual laws. Like this is the law on homicide. This is the law on burglary in North Carolina. 15A is all the laws broken down into different parts, these articles from the chapter, about procedure. Like where do you go to get a search warrant? Who has the authority to issue a search warrant? What has to be in a search warrant? So there are 101 different articles that you can do. So it's 15A, but there's a lot of blanks in there. So you'll notice that articles 7, 19, 22, 21, 27, 28, 33, 34, 40, 41, 47, 54, 55, 63, 64, 74, 75, 76, 79, 87, 93, 94, 95, 96, 97, 98, 99 are all blank. And the reason for that is very simple. Because things change. Prior to this, there were more blanks because there were no such thing as cell phones. Once cell phones come in, you might need a new procedural law to, this is how we're going to handle cell phones. After this Apple case, there might be a law passed in general legislature talking about it, and it might become part of the procedure. If you want to see this, you can go to, again, all the North Carolina laws are published and available online by the North Carolina General Legislature maintains a website, so you can always find them. Now, even though I've been an attorney for going on 30 plus years, I don't know all of them by heart. I still have to look up individual ones. Some I'm very familiar with. This is true of criminal law as well. This is true of procedural law. This is true of a ton of laws. You might know the law. Even if you know the law, I know the law of burglary. I know the law of prostitution. I know the law of assault pretty well. But there might be, some facet of my current case that I'm going to have to go look up some more information about. That's when I go to those cases. So let's just take a quick example here. Let's suppose that I have a burglary case. And what happens is my client was walking in the woods, saw a tent, right? Looked in the tent, saw a $10 bill lying on top of a sleeping blanket, took the $10 bill. Okay, here's the question. Is that a burglary? Is a tent a home? So if you look at the North Carolina General Statute for burglary, it says you break and enter an occupied dwelling. And then, depending whether it's first degree or something, it says at night. Okay, well, is a tent in the woods a dwelling? Well, you got the statute. You could look up the statute, and the statute would say, here it is. That's not going to be as helpful as I better look at the North Carolina case law, going back to those cases, okay, and see if there is a case where the Supreme Court heard, or the North Carolina Court of Appeals heard, a similar case about someone entering a tent and taking money or taking something, and the North Carolina General Court said, yes it is, or no it isn't a burglary. See how helpful that would be to me? So even though I've got these rules, both of procedure and of evidence, I'm going back here, I know, I still want to go back to these cases, these citations, because they're going to flesh out the law for me. So a lot of what I'm going to teach you in this class, going forward here, are really going to be all about these cases. both North Carolina, where I'm going to apply those a little bit more outside of your text, but also importantly, the federal cases, because that's going to apply across the whole United States. So we've got the rules of procedure, we've got the rules of evidence, okay, and we've got those court cases. And that's a lot of what we're going to be doing in here. Now, starting in our next lecture, chapter 2, we're going to move from the very general to the little bit more specific. We're going to move on from the very, very general to, okay, let's look at some specifics in regards to that important document that really frames what we, how we practice as lawyers and what we do, and that is the U.S. Constitution. You know, again, we'll end this lecture talking about Benjamin Franklin. You know, one of the questions was, when the American Revolution broke out, was what kind of government was going to take its place. You know, we've been ruled by a king through a parliament, and the question was, were we going to, like everybody else was at the time, going to be a monarchy? Were we going to elect a monarchy? So Benjamin Franklin, it's possibly an apocryphal story, was leaving the convention, the Constitutional Convention, and he was stopped by a citizen and said, Dr. Franklin, what do we have? Do we have a monarchy or do we have a republic? And Franklin said, you have a republic if you can keep it. So one of the things about this balancing act between freedom and security is that every generation has to keep the republic. Every generation has to keep enough of the freedom and enough of the security to go forward and pass this to the next generation. And each generation defines how safe they want to be and how free they want to be. Some generations are more interested in being free, some generations are more interested in being safe. And that is a lot of the history of both the law and the United States. Well, I look forward to teaching you all. This first lecture is going to come in at about 50 minutes. In the future, they're going to be slightly longer than this usually because I'm going to have a little bit more supplemental material. Also, there were a couple of typos in here. I'm going to go back and fix them. I won't change this lecture, obviously, but if you look at the individual PowerPoints that will be available to you, you'll notice that I will have fixed some of the typos, and I'm sure there's more. I usually hear about it from people. This will be posted on YouTube and will be closed captioned. So I'll be getting these up. I'll probably do about 2 a week, maybe 3 a week. And these will be up and available to you. All 15 chapters, I believe, of our text will be up and available by the time classes start. But I'll be going through obviously one at a time, so I'm existing at a different time than you are. Okay, at that note, you all have a great day or good afternoon or great evening. And I will see you for lecture 2 whenever you're ready.